The Homesteads Act gives special protection to the family home and provides rights to a spouse or common law partner of an owner to live in the property for the duration of their life, which is known as a life estate. This right continues even if an owner's will leaves the property to someone else. Additionally, the Act requires the spouse or partner to give written consent or sign a release of their rights for the property to be sold or mortgaged. If both spouses or common law partners are on title and they are party to the sale or mortgage, they do not need to provide further consent. The Act defines a homestead as a residence occupied by the owner and the owner's spouse or common law partner as their home. The amount of land included with the residence depends on whether the residence is in city, town, or village, and other conditions described in the Act. In the case of a condominium, the homestead includes the condominium unit and common interests within the meaning of the Condominium Act. A person may only have one homestead at a time. An individual gains homestead rights once they are married, have registered their common law relationship with Manitoba Vital Statistics, or have been in a conjugal relationship for at least 3 years. Only one spouse or partner may have homestead rights in the family home at a time. If the owner brings a subsequent spouse or partner to live in the home, that individual does not acquire homestead rights until the rights of the first spouse or partner have been released or terminated. Homestead rights only end when the property is sold, with consent or as a party to the sale. The person with homestead rights signs a release, or the court orders that the rights be terminated. When you are preparing to list your seller client's property for sale, it is important that you ask them whether anyone has homestead rights in the property. While a non-owning spouse or partner does not sign the listing agreement or the offer to purchase, they will need to give written consent attached to both the offer to purchase and to the transfer of land for the sale to proceed. If the non-owner has been living apart from the owner for 6 months or is not mentally competent to give consent, an application can be made for a court order to proceed without consent. If your seller client believes that they will not be able to obtain consent from someone who has homestead rights, they should speak to their lawyer about their options. When representing the seller, you must ensure that Section 12 of Part 1 of the statutory offer to purchase form is completed correctly to indicate whether the property is a homestead and whether anyone has homestead rights. Read each option carefully. Check the first box if the property does not meet the definition of a homestead as described in the Act. For example, if the property was a rental property and the owner never lived there as their primary residence. Additionally, if there is a release of homestead registered on title and there is no new spouse or common law partner, consent is not required, and the first box should be selected. If the property is a homestead, but the names of both spouses or common law partners are on the title, and there is nobody else who has homestead rights, check the second box. If the property is a homestead and there is an individual with homestead rights, the third box must be checked, the name of the individual with homestead rights written on the line, and a consent to disposition and acknowledgement form must be completed and attached to the offer. Note that the consent form cannot be completed electronically, nor can it be completed before an offer to purchase has been submitted to the seller. This form must be witnessed by a commissioner for oaths or another person authorized to take affidavits under the Manitoba Evidence Act. Registrants may wish to consider becoming a commissioner for oaths to facilitate the completion of the homestead consent form. Be mindful that for marital property located on First Nation reserve land, the Federal Family Homes on Reserves and Matrimonial Interests or Rights Act applies. However, individual First Nations may also have their own matrimonial real property laws. If you are ever unsure whether homestead rights or other marital property provisions apply in your client's situation, you should direct them to get clarification from their lawyer.